everyone, my name is Aaron and today I would be explaining the concept of mortgages. To begin, this question is regarding the topic on mortgages, and the objective of this question is to determine what factors do the courts take into account when deciding an application for postponement of possession order when there is insufficient proof from the mortgagor. Firstly, mortgages are used to finance the purchase of a home and would be explained by the case of Santley v. Wild, where a mortgage is the conveyance of land which acts as a security for the payment of debt and transfers the deed when the debt is paid off. In the case where a mortgagee includes a clause in the contract to prevent the transferring of a deed although the debt is paid, the case of Jones v. Morgan established that any clauses which interferes with the mortgagee's right, it would be held as inconsistent with the mortgage. Prior to 1926, the law on property was based on common law. When it came to mortgage, land was leased to a mortgagee and the right for redemption was based on a contractual agreement, and defaulting on payments were subjected to harsh consequences of common law. However, this equitable redemption, where land could be redeemed through equity, and this clause shall not be prevented as established by Quirlinger v. Patagonia Meat and Cold Storage Co., where the equitable right to redeem was not postponed or excluded by a clause in a mortgage agreement. The law of mortgage was later reformed after 1926, where a mortgage does not happen through the transfer of the mortgagee's right to the land to the mortgagee. Legal mortgages are now created by Section 23, Sub 1, Para A of the Land Registration Act 2002, in short LRA, where a mortgage of registered land can be created is by registered charge. Registered mortgages is where a mortgage has to take the approval from the sub-registrar to create the agreement, and the mortgagor and the mortgagee are bound by the terms for the tenure of loan by a third party. Under Section 52 of the Law of Property Act 1925, in short LPA, charges by legal mortgages must be created by a deed, and Section 27 of the LRA 2002 states that the mortgage is only enforceable when it is entered onto the title of registered land. The case of Barclay Bank v. Zurababli illustrates that by failing to register the mortgage, it would prevent the creation of a legal lease of land. Equitable mortgage is where terms of agreement are made between the mortgagor and mortgagee where third parties are not involved. In creating equitable mortgages, the borrower must have equitable interest on the land, and under Section 53, Sub 1, Para C of the LPA 1925 requires the transfer to be written. Furthermore, an equitable mortgage is enforced by statute, which is established by Section 27 of the LRA 2002, and in the case of Cheltenham plc v. Appleyard, where the registration of a mortgage failed due to obstacles created by the previous lender and the mortgagee had to take an equitable mortgage. Under Section 2 of the Law of Property Act 1989, in short LPMPA, terms agreed by the parties must be made in writing, and Section 2 Sub 3 of the LPMPA 1989, the document will be valid if a witness manages to witness the parties signing it. In Walsh v. Lonsdale, written agreements will be valid and will be enforceable as an equitable mortgage. Before the LPMPA 1989 was enacted, a mortgage can be created by depositing the deed to the mortgagee, but after its enactment, a written contract must be present for the mortgage to be valid, and this was affirmed in United Bank of Kuwait v. Sahib, where the deposition of title deeds itself were not sufficient to create a mortgage, as a written contract must be present. Remedies available for mortgagees if there is a dispute: mortgagors have the right to sue the mortgagor, right to foreclose, right to appoint the receiver, right to take possession, and the right to sell the premises. When the mortgagor defaults, the mortgagee can sue on a personal level under Section 88 and Section 89 of the LPA 1925. There is a judicial order to make the mortgagee the owner of the mortgaged land. This action is known as foreclosure. However, in Polk v. Mortgage Services Funding plc, it was stated that foreclosure proceedings are rarely used today. Also, the mortgagee has a right to appoint a receiver, which is established by Section 109 of the LPA 1925. This remedy is where the mortgagee has a say in the mortgaged land, and that is on lease, and Section 109, Sub 2 of the LPA 1925 states that the mortgagor would be liable for the receiver's acts Not only that, in the case of Medford v. Blake, which also established that a receiver has a duty of care to the mortgagor to maintain the land. The next right of a mortgagee would be the right to take possession, where the general rule would be laid out by the cases of Four Maids Limited versus Dudley Marshall Limited, where the mortgagee would possess the property as soon as the agreement is signed. In the case of Ropelich versus Barclays Bank plc, where it was established that the mortgagee can possess the land anytime. However, the court may provide exceptions for a specific period of time, as seen in Birmingham Citizens Permanent Society vs. Colt, where if the mortgagor could prove that he could repay the mortgage at a specific amount of time, the postponement of land would be granted. However, in the case of Grinnell vs. Maltby, the Court of Appeal did not allow the claim for security of land, as the claimant had the intention of ending the lease. He be granted to vacate the land, as therefore the courts refused to grant a relief due to the claimant's unsanctioned act. Moreover, Section 36 of the Administration Justice Act 1970, in short AJA, and Section 8 of the AJA 1973 provides that the discretion to courts to postpone possession of a dwelling house of the mortgagor if the court thinks it is reasonable to do so. This would be illustrated in the case of Cheltenham Gloucester Building Society vs. Grant. The judge suspended the possession of the property to give the mortgagor time to get back on his feet. However, if the likelihood of repayment can be only made on assumptions, the court will be reluctant to grant a relief, as seen in the case of Bristol and West plc vs. Days. The final right of the mortgagee would be the right to sell the premises. This will only be available if the requirements under Section 101 of the LPA 1925 are satisfied, where the mortgage was created by deed, and the mortgage debt must be due, and the mortgage deed did not state that the mortgagee did not have the power to sell the property. To put this right into action, the following provisions under Section 103 of the LPA 1925 must have occurred where the notice of default was given 3 months prior, or the interest owed has reached at least 2 months, or there is a breach on the mortgage agreement. An order for sale can be applied by the mortgagee or by anyone who has a right to redeem the land, and this is laid out under Section 91 sub 2 of the LPA 1925. This would be affirmed in the case of Pauk versus Mortgage Services Funding plc. The court had the ultimate decision on whether to grant an order for sale. Moving on, when a mortgagee enters into agreement to sell, the mortgagor may not stop the sale by paying off the debt. This position was taken in the case of Lord Waring versus London and Manchester Assurance Co. Limited. The mortgagee has the ultimate discretion when selling the property, and has the discretion to sell as established by the case of Cutmere Brick Co. versus Mutual Finance Co. Under Section 105 of the LPA 1925, the outcome from the sale is to pay off the costs for the sale and discharging the mortgagor of his debts, and the balance will be paid to the mortgagee. Moving on, the next topic would be the mortgagee's right. The first right would be the right to redeem. The general rule here is that there is a legal and equitable right to redeem land, as mentioned earlier. Furthermore, no mortgages are irredeemable. In Jones v. Morgan, a land was going to be repossessed, and an agreement was concluded which stopped it. The mortgage agreement allegedly gave the mortgagee to buy half of the mortgaged land. The Court of Appeal held that this agreement was unfair, as it will clog the equity of redemption. Besides that, when there is a separate transaction as seen in Samuel v. Jarrah Timber and Wood Paving Corp., when an option was given to the mortgagee to buy the mortgage stock, the court decided that because of this option, it would intervene with the mortgagee's right to redeem. For the postponement of redemption, it applies differently to a leasehold and a fee simple property. For the postponement of redemption for a lease property, if the postponement is far too long, the postponement will be nullified. This was seen in the Australian case of Fairclough v. Swan Brewery Limited, where the court held that the mortgage was void due to the duration of the agreement was unreasonable. For the postponement of redemption for a fee simple property, unlike the lease property, a period of time set for postponement could be indefinite, but the postponement depends on the factors of each case. In Knightsbridge Estates v. Bryan, the mortgagors entered into a mortgage of freehold land, and a mortgage for freehold land contained a covenant to repay the loan over a 40-year period, and the mortgagors later wanted to redeem their property 6 years after entering the mortgage, and argued a term in the agreement was a clock to equitable redemption. However, the court held that the terms of contract was not unconscionable and oppressive, thus the term was valid. For a term to be struck down, the term has to be unconscionable or oppressive or be of undue influence. This would be further supported by the case of GNC Kreitlinger versus New Patagonia Meat Cold Storage Co. Limited, where the unfair and unconscionable which contained the nature of a clause preventing the equity of redemption and is also inconsistent with the principle of equitable redemption. On oppressive bargains, the general rule is that the courts has the discretion to strike down terms in a mortgage that has an oppressive or unfair nature. Oppressive terms would be illustrated by City Land Properties versus Dabra, where a high interest rate would lead to the equity of redemption to be invaluable, and in Paragon Finance PLC versus Pender and Honor. It stated that a lender has a discretion to increase interest rates but must however be reasonable and be operated in a fair manner. For undue influence, the purpose of equity is to defend the party who is at an unfair advantage in a contract. To conclude the presence of undue influence, the classes of it was established in the case of Bank of Credit and Commerce International SA versus Abudi. Where Class 1 will require evidence of the influence, Class 2 is where undue influence is presumed due to the relationship between the parties, such as a parent and child, seen in the case of Wright versus Vanderplank. And Class B would be where evidence is required to prove that there was a relationship of trust and confidence was established. In the case of Barclays Bank versus O'Brien, a husband used his house as collateral when the bank was repossessing it. His wife claimed that she was unduly influenced in signing the agreement. It was held that the wife had the rationality to think for herself, thus the defense of undue influence failed. During an application for possession, the courts will firstly look at whether the mortgagor had reasonable time to repay the mortgage. If the mortgagor was not given that reasonable time, the court would grant a postponement of possession. This would be illustrated by the case of First National Bank versus Syed. The courts would also further look into why the mortgagor defaulted in the first place and whether the reason for the incapacity is permanent or temporary. And not only that, the court would have to think in the shoes of the mortgagee by taking into consideration whether the duration needed to repay the mortgage would be reasonable to the mortgagee. If the court finds that the mortgagor has the sufficient capacity to recover from his financial difficulties, the court may grant a postponement of possession order, and this would be illustrated in the previously mentioned case of Cheltenham and Gloucester Building Society versus Grant, and also in the case of Cheltenham and Gloucester Building Society versus Crops. The court granted the mortgagor 13 years to clear the amount he defaulted on. The option to apply for a postponement of redemption order, it may seem like an advantage solely for the mortgagor. However, it is also to assist mortgagees to achieve their objectives, which is to get back what they lent out. The Civil Justice Council, CJC, proposed radical and important reforms for the repossession process for mortgage arrears. The proposal suggested that the same principles would still be applied, but lenders should additionally advise the borrower to get in touch with a local authority for welfare benefits. However, this was criticized as banks should not have the responsibility on advising borrowers. But as mentioned before, the mortgagee's objectives are to get their money back. Therefore, by advising borrowers to apply for financial relief, it may help get their money back. As we can see from today's ongoing COVID-19 pandemic, most if not all mortgages would be facing financial hardships to make payments. Therefore, the civil procedure rules was amended to cope with the COVID-19 situation, where the CPR 55.A1 states that if a judge is satisfied that the defendant has proven exceptional hardships, he will postpone possession without conducting a hearing if he considers the possession should be given up to 6 weeks after the date of order, and the claimant has to show that he would be satisfied if the court was to make such an order without a hearing. Furthermore, the UK Chancellor on March 2020 announced a series of measures to assist businesses and individuals who are financially affected by the pandemic. The measures given are such as where mortgage payment holidays are given, where mortgages are given a specific amount of time to not pay their mortgages. Next, the Financial Conduct Authority, the FCA, also advised banks to practice forbearance when it came to repossession. And lastly, the FCA expects firms to help customers understand their debt and provide money guidance advice. The next issue I would like to talk about would be how mortgage repossession would breach Article 8 of the Human Rights Act 1998 by interfering with an occupier's right to enjoyment of land. Here the HRA is to protect citizens from any abuse of authority by public authorities, not regulate relations between private individuals or companies. Therefore, the Human Rights Act 1998 is inapplicable to courts when deciding whether to grant a postponement for possession order. The case of Ropalich versus Barclays Bank plc illustrates a possession by a mortgagee when the mortgagor defaulted and how the court would strike down or suspend the possession with its powers given by statute. Here, the bank did not have an order of possession from the court and sold the mortgagee's property by auction. The mortgagor sued and argued that the mortgagee did not have the right to sell the land without an order for possession. The mortgagee argued that they did not need an order for possession of the property as they already had the right to do so and were not limited by contractual terms. The issue here is whether the mortgagee had the right for possession and the Court of Appeal agreed that they had the right to do so. For the second issue, where the bank claimed it did not possess the property but only executed the right to sell on grounds to keep the mortgages out. Therefore, it would not be possible for mortgagors to apply for a relief as the equitable right of redemption would be extinguished. As we can see, the mortgagor did not limit the mortgagee's right to sell in the contract. In conclusion, courts would consider whether the mortgagor had reasonable time to repay the mortgage, also look further into the reason for arrears, and whether the incapacity to repay is permanent or temporary, and not only that, the court would have to think in the shoes of the mortgagee by taking into consideration on whether the duration needed to repay the mortgage would be reasonable to the mortgagee. The court does not only rigidly follow these principles but also take into account of external factors such as the COVID-19 pandemic. The reasoning behind this is to ensure equity and that people are not subjected to harsh consequences by legislations. Furthermore, the provisions laid out by the AJA gives flexibility for courts to decide on granting orders for postponement of possession, thus further upholding the principle of equity. That would be all for my presentation, and thank you for watching.